Delivery of judgment WPC 4755/19 Zaharul Ali versus the Union of India and others.
May I please, Lordship, I may be allowed to see the record of item number 3. I'll check.
Delivery of judgment WPC 2149/19 Sahara Begum versus Union of India and others.
This petition is dismissed and this is read from minutes.
May I please, Your Lordship? I'd like to mention item number 7 from the supplementary list, Your Lordship. Item number 7 from the supplementary list. My senior is having some medical issue, Your Lordship. So the matter may be passed over for the day.
Item number 18.
Item number 7, Your Lordship, for supplementary list.
Supplementary list 7. Yeah, no. So wrong. We don't have a supplementary list, item 7.
Editor.
Which court you are mentioning? We don't have item 7 in supplementary list.
There is no supplementary list. 18 item 18. Item 18. My apologies. Item 18. Like
Daily list item 1 for motion WPC 6278/19
Yes, may it please your Lordship. My lord, the in opinion, my lord, your Lordship will find at page 63, my lord, annexure 3, my lord. However, my lord, the petitioner was declared as a foreigner, my lord. Despite of submitting and exhibiting some documents, my lord, pertaining to the nationality of India, my lord.
There were a lot of discrepancies.
My lord,
Let's see the documents.
mainly, my lord, the same name as well as age, my lord. And it was also, my lord, was my lord, some documents, my lord, which was not proved, my lord, that were not considered, my lord. Yeah, my lord. Petitioner's father, my lord, father's name is Sabed Ali, my lord. His name was recorded, my lord, in the voter list of 1965, my lord, as Sabed Ali, my lord, along with his grandmother, my lord, PS 15, my lord, on 5.
Yes.
My lord, PS 15, my lord, on 5, my lord. Your Lordship will find, my lord, the petitioner's father, my lord, whose name is actually name is Sabed Ali, but here in this voter list, my lord, his name was recorded as my lord Sabes Ali, my lord. My lord, village is the same, my lord, Rampur Chhatro, in the Nogar district, my lord, under King PS, my lord.
Yes.
Thereafter, my lord, case 17, my lord, the voter list of 1971, my lord. Here, my lord, on Abed Ali, my lord, he is the uncle, my lord, of the petitioner, my lord. His name was recorded, my lord, as well as my lord, the mother of the petitioner, my lord. Amazon BB was recorded, my lord. Case
Where is your,
17, my lord.
where is your written statement, which page?
Written statement will Rosh will find, my lord, at page 52, my lord. Very comprehensive written statement, my lord. My lord, yeah, my lord, at paragraph 4, my lord, of the written statement, my lord. The petitioner had mentioned about the electoral law of 1965, my lord. And paragraph 5, my lord, it has mentioned about the electoral law of 1971, my lord. And paragraph 85, sorry, paragraph 6, my lord, 1985. And paragraph 7, my lord, yeah, my lord, yet it was stated that the petitioner's own name, my lord, was recorded along with her father, my lord, 1997, my lord. Total list of 19. That the appellant opposite party is not a foreigner, the opposite party's father and her name is enlisted in the voter list of 1997. Assam district constitution of 84 number voter draw constituency. As Sabed Ali, my lord, the father names of the petitioner. Paragraph 7, my lord. Now, my lord, your lordship may kindly come to page 33, my lord, the voter list of 1997. My lord. Here, my lord, the first one is a petitioner's father's name, second one, my lord, petitioner's, my lord, mother, third one, petitioner's brother, and fourth one, my lord, petitioner herself, my lord. Now, my lord, your lordship kindly come to page 35, my lord. Here, my lord, India 1997, my lord, sorry, 96, my lord, the petitioner had appeared in the matriculation examination, my lord. That admit card was also annexed, my lord, and exhibited as exhibit 8, my lord, page 35, my lord. Wherein, my lord, his father's name was written as, my lord, MD Sabedai. Then, my lord, petitioner had also, my lord, had exhibited, my lord, on the copy, my lord. Exhibit 6, my lord. Pertaining to year 1930 and 31, my lord. Page 36, my lord. In the name of petitioner's grandfather, my lord, Talib Hussain. Therefore, my lord, page 39, my lord. On held it, my lord, that was also exhibited, my lord, pertaining to year 1967, my lord, that was exhibited between the petitioner's father, my lord, and on Akka Sahib. Page 39, my lord. Held it. So case 48, my lord, the Gabura certificate, my lord, issued by the Gabura of the concerned, my lord, Rampur Satra village. Case 48, my lord.
There are so many documents which are not in serial order, especially exhibits. We are getting confused because there are a lot of documents which are unexhibited documents. You prepare a list of documents and the page number and give it to us. Write the exhibit numbers and give the page numbers to us. We find it difficult to follow you. Exhibited. Like us. We already have this petition. Just give us a list of exhibits and the page numbers. We are finding it difficult to follow you. We are compelled to make our notes with regard to your exhibited documents very clumsy. Unexhibited documents don't refer. Only the exhibited documents give the voter list number and whatever it is, 1 to 4, give a list. We're finding it very difficult.
Can we take an again after tomorrow? Or next week, madam?
Next week. What's that? Exhibited documents and indicating the page number.
Page number.
Yes. On the day after.
Item 2.
May I pray, Lordship?
Yes.
Lordship, this item may be taken up on day after tomorrow, Lordship, because of my some problem in the election of our country.
Elections are in problem.
Only for that 2 days, Lordship.
Tomorrow is election.
Huh?
Tomorrow is the election, by now.
After that also she'll have to celebrate.
No, 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 sir. No, no, Lordship, this is not
Well,
correct.
it's a big bank, 5,000 people, you'll have to give treat. Next week.
Next week.
Thursday, Lordship.
Next week.
Next week. Lordship.
What's the represented on the fair made by in the same day and out of the petitioner. Matters and they don't based on your data. So my court master says it goes after 2 weeks.
Right, Lordship.
Item 3 for motion.
May I please, Lordship? So I just now I've gone through the record also, no? So Lordship, I'll just, I may be granted some time, because I'll suggest my client to apply for the car, registration of car.
And made by the foreman.
God bless.
Supplementary item 18 for motion. Supply item 18.
Portion. 18 probably that, mother 18 was mentioned, mother. Oh. Yes, that was for 18 months. Twenty.
Item 4 for admission.
Lordship, Vinati, if you are in this matter, is on late, Lordship. Kindly you can expect some time.
Item 5 for admission.
I also Lordship, Vinati. Yes.
Item 6 for admission.
My lord,
My lord, my lord, the judgment in appeal, my lord. Your lordship will find it page 227. My lord, if I may be permitted to place the brief facts, my lord. My lord. No, my lord, there are certain other layers to it, my lord. What had happened? No, my lord.
It's not been done.
It's not been done.
So that this order was on 4/11/25.
True, my lord.
So for 5 months, you have not complied with the direction.
No, my lord. That is, the order was passed, my lord, on 4/11/2025. If your lordship may kindly peruse, the additional affidavit that you have filed, my lord.
Yes.
The additional affidavit, my lord. Your lordship at page 251.
Yes.
My lord, there is a summon, my lord, dated 14/11/2025. Sir, in pursuance of the judgment and order from the Honorable Gauhati High Court regarding case number so and so dated so and so, Professor so and so versus Gauhati University and others, the Honorable High Court, the Honorable Court has directed the petitioner.
Sharma, you please take instructions because we may close that chapter altogether.
No, my lord, what has happened now, that I have been subsequently, my lord, I had prayed for some adjournment of the cross-examination on the ground that,
You tell us, take instructions and tell us by when you will do it. Otherwise, we'll close that chapter.
my lord, we do it tomorrow if your lordship permits. I just want my right to be cross-examined, to cross-examine the prosecution witnesses. The reason, my lord, I did not do it at the earlier instance, my lord, was that
Prosecution witness.
the cross-examination, my lord, of the state witnesses, my lord, of the Gauhati University, my lord. So I was not given a chance to do that. Now, when this matter, my
But this allowed you.
this court allowed me to, my lord. This court allowed me to, and pursuant to this honorable court's order, my lord, the Gauhati University was very correct in issuing us this summon dated 14/11. Pursuant to that, my lord, I had preferred a reply on 2011, which is at the next page, stating that an appeal has been filed. Now, the appeal was filed on the primary ground that the learned single judge had remanded the matter to the stage of cross-examination. I, my lord, being the incumbent here, I was aggrieved by the conduct of the inquiry officer through and throughout the disciplinary proceeding, pursuant to which, my lord, I prefer this appeal, praying for setting aside of the entire DP from the moment of show cause. Now, when the matter, my
You
lord,
see, we are also subjected to the same treatment.
true, my lord,
Correct.
true, my lord.
What you call, let us test this submission. Few days back, an incident happened.
Absolutely not, my lord. True, my lord, true. No, true, my lord. Absolutely, my lord. In fact, my lord, your lordship is very correct. In fact, the grievance of the appellant, it started from the fact that the list of witnesses initially in the memorandum of charges was changed at a later point in time, which is recorded in the learned single judge's order. Then when the inquiry report was prepared, my lord, the inquiry officer went ahead out of the mandate of Rule 6 and he recommended my removal from service, which he could not have done that. And there are other surrounding circumstances also, my lord. Now, when this matter initially was taken up before the learned court number 1, my lord, on 9/3, there was a query which was posed before the counsel for the appellate, my lord, that in the absence of specific allegations of bias against the inquiry officer, can or could the inquiry officer be changed? And pursuant to that, my lord, to my lord, my lord, my lord. True, my lord. My lord. My lord. True, 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 my lord. True, 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 very true. And in fact, my lord, when the inquiry, so, no, I understand that, my lord, my appeal does not stand on very strong footing in the eyes of law because there are certain conduct which cannot be substantiated and have not been substantiated. Today, my lord, today as I understand, which has been stated in the additional affidavit also, that I have been subsequently removed. Pursuant to the summons dated 14/11, I have been removed, which I did not participate in, my lord, on the ground that there is an appeal pending. I have been removed. There was an advertisement which was also floated for the post of registrar. Now, those two subsequent actions, my lord, I have challenged before the learned single judge, which is listed tomorrow. Now, the only relief which I seek today, my lord, is that your lordship might be very well within your lordship's right to, my lord, dismiss the appeal. But the right which was granted to me by the learned single judge, which could not have been exercised, which could not be exercised by me out of utmost bona fide, my lord. At least let the Gauhati University undertake that process, even if it leads to my subsequent removal again, because I've been removed twice right now. The second time where I did not participate. The lordship can allow them, and the subsequent writ petition is subject to the whatever happens to my whether I'm retained or removed. That is the extent of my prayer, my lord. My lord, my lord, my lord. True, my lord. My lord.
Means that this proceeding
My lord.
has been brought to the fighters by
Yes.
by removal or order of removal.
Yes, my lord.
But if that be so, then we can't put subject to cross-examination of the witnesses again. That would amount to reopening of the
No.
of the
The entire DP, my lord.
inquiry.
No, what has happened, my lord? What has happened is that there was a list of witnesses who were appended to the initial memo of charges. pursuant to, because there are other litigations also prior in time, I could only cross-examine two witnesses. And my right, which was granted by the learned single judge, was limited to the extent of cross-examination of those witnesses which I could not examine. Now, the summons at page 251, my lord, those witnesses have never been cross-examined, even during the usual course of the DP and the subsequent course of DP pursuant to the
But there will be no information in the order of the learned single judge. You'll have to challenge this removal again.
no, my lord,
Another repetition.
no, yes, no, that is pending. That is pending. That will be listed tomorrow, my lord. The additional affidavit, the order has been annexed.
Without prejudice to your right in that repetition.
My lord.
It can be closed.
No, because my
Right
lord,
can't vegetate.
because the infirmity with my removal and the subsequent advertisement stems from the fact whether this appeal can be allowed or not. Now, if your lordship dismisses this appeal, then the other case, my lord, before the learned single judge, will have no basis to stand on. Now, my basis to stand on would only matter, my lord, if I'm able to cross-examine the witnesses subject to your lordship's discretion, my lord. And if I can do that, whatever happens, if I am removed or I'm retained, at least then I can take that issue later on. But now I have been removed again without having a right, without being able to cross-examine the witnesses on the,
That's a subsequent cause of action.
that has been challenged, my lord.
Now, let us, you see, when we are dealing with an intra-court appeal,
My lord,
we have our own limitations.
true, my lord, true,
So we'll have to find out that whether this order which has been passed
true, my lord.
is sustainable or not.
True.
And whether the discretion exercised by the learned single judge can be substituted by the division bench. That is the,
That is the crux of it, my lord. That is the crux of it, my lord.
now, in this case, please come to your memo appeal.
My lord.
Seven one, grounds are at page 12. 7.1 is the element of bias.
My lord.
On this, you have given 8 subparagraphs. So therefore, it's only a case of bias.
Only on the case of bias, my lord. Now, if my case against bias, my lord, fails before this honorable court, my prayer is that I be given the liberty, my lord, to exercise the right which was granted to me by the learned single judge. That is the extent of it, my lord. If the appeal goes and the learned single judge's order stands, then a direction at page 242, since there is some finality to it from this honorable court, I did not partake in the cross-examination on the utmost bona fide that there was a writ appeal which was filed challenging the learned single judge's order. The university proceeded anyway. Now, if that right is given to me in specific terms stating that the appeal is dismissed, now you go and cross-examine, my lord. At least I'll have some comfort, my lord, that is the last tether of my service career, my lord. My last fight, my lord. Nothing beyond that, my lord. Page 242, if the right which is granted in page 242 is granted, I'll be grateful for this court benevolence, my lord.
Mr. Sharma.
My lord.
Finally, you see,
My lord.
you were biased, your allegation of bias
My lord.
arose because of that inquiry report of 13/2/2025.
Along with other,
Whatever,
My lord,
but that
sir,
is the basis because you say that
he exceeded the mandate, my lord.
the inquiry officer exceeded jurisdiction,
My lord.
the, what you call, you say that he's the retired, IS,
IPS officer, my lord.
officer,
And
and therefore linked to the police and vigilance and so and so, so therefore the bias is because of his, post he was holding earlier,
the proximity to the witnesses, my lord.
proximity. Now, then you say that one of the grounds is that the criminal trial is going on, so therefore that should be, that should be
No, my lord.
stayed.
And that may not hold true in the light of High Court tangent or its own.
Then you say that because the inquiry report was accepted,
By the executive council.
then the asking you to give a response is a empty formality,
Oh,
that's
fine.
the view taken.
My lord.
But the learned single judge,
My lord.
taking note of your,
All of it, all of
plea,
it, my lord.
it set aside the inquiry report
It did, my lord.
and
It did.
gave you an opportunity to,
Cross-examine, my lord.
to cross-examination.
True, true,
Now see if that inquiry report goes
my lord.
and it starts from the de novo stage of cross-examination. How do you sustain the allegation of bias?
No, because the allegation of bias, my lord, stemmed from the office of the inquiry officer. And the inquiry officer remained as it is, my lord, without the inquiry officer, because that was our initial prayer in the repetition to have completely set aside the disciplinary proceeding, my lord. Your lordship permits me to take your lordship's attention to page 240, my lord. Paragraph 13, my lord.
I tell you something,
My lord.
this is the age of AI. You are aware of the bias which is being alleged to an artificial intelligence. You have read the articles on that.
Not-
I'll tell you. You see, we are sitting in a bench which is primarily dealing with foreigners tribunal cases. Now you take out 100 judgments which we have given and then say that
Will they have succeeded? There were true. True, my lord. Absolutely. Yes, absolutely, my lord. My lord, my lord. My lord, the likelihood of my removal majority of the cases would go the other way. No, my lord, that cannot be a parameter of bias. That cannot be a parameter of bias. My lord. My lord. True, my lord. My lord. But my lord, my question would also be surrounded by ancillary facts, my lord. Your lordship had given a correct example, my lord. The likelihood of my matter being allowed or disallowed would not lead to bias. The likelihood of me presenting a case and then my matter being allowed or disallowed would lead to an element of bias, which has happened, my lord, before the appellant had approached the learned single judge. There were other instances of a liberty granted by the honorable single judge to cross-examine the witnesses, pursuant to which I preferred an application which was rejected. The list of application, the list of witnesses was changed midway. Then he goes ahead and recommends my removal. So all of those surrounding situations, my lord, will kindly come to page 240, my lord. This is the honorable single judge's observation of the facts, paragraph 13, page 240, my lord. Paragraph 13, page 240. My lord, if I am permitted to read, my lord, what clearly transpires. My lord. What clearly transpires from the above is that the writ petitioner only cross-examined two prosecution witnesses, number 1 and 3, that is so and so, and could not cross-examine the other prosecution witnesses, as his prayer for consideration of a defense assistant was sub judice before this court on both the dates of hearing, that is 16/1/2025 and 27/1/2025. It is further evident that despite the direction of this court in the said writ petition to the respondent to grant a fresh opportunity to the writ petitioner to cross-examine the said witnesses, the same was not granted despite receipt of the letter dated 30/1/2025. It is further apparent that likewise, the disciplinary authorities accepted the finding of the inquiry officer and issued a show cause notice by the impugned notice dated 13/5/2025. Seeking as to why the proposed penalty of dismissal from service should not be imposed upon the writ petitioner in a perfunctory manner. Paragraph 14. As regards the contention of Mr. So-and-so, Learned Standing Counsel, Gauhati University, that on 16/1/2025, while the respondent university examined the said three witnesses, the writ petitioner had declined to cross-examine them. This court cannot be unmindful of the fact that on that date, that is WPC 351/2025, was pending before this court for consideration of the writ petitioner's prayer for grant of defense assistant in the inquiry proceedings, and subsequently on 27/1/2025, this court specifically directed the respondents to grant the opportunity to the writ petitioner to cross-examine the said witnesses. That being so, my lord, assistant, but to be a lawyer, my lord, because the inquiry officer had a degree in law. Ideally, the rule is that if the presenting officer has a degree in law, only then you are entitled to a legal assistant, my lord. In this case, my lord, the inquiry officer had a degree in law, my lord, and we had approached the court seeking that a defense assistant be having a legal background, my lord. So, but all of those communications were duly made, and the university, my lord, on multiple occasions. My lord. That declined, my lord, and that declination was challenged for this honorable court, and it was duly communicated to the authorities that I have approached this honorable court. The matter is pending. It will be shortly adjudicated. Kindly grant me leave of 1 day. But it proceeded anyway, and this is exactly what happened pursuant to the conclusion of the second writ petition, which is under challenge, ma'am. They had proceeded immediately after 7 days, ma'am. Immediately, my lord. And my lord, if I may continue, my lord. That being so, the inquiry officer, upon receiving the letter dated 30/1/2025 and having been brought to notice as regards the judgment and order dated 27/1/2025 passed by this court in WPC number 3551/2025, ought to have complied with the aforesaid direction by granting the opportunity of cross-examination to the writ petitioner, as they have not been earlier cross-examined by the writ petitioner. Interestingly, there has been no response or consideration whatsoever to the said letter dated 30/1/2025 by the inquiry officer. In fact, in the affidavit in opposition filed by the respondent university, there is also no whisper as to why the judgment and order dated 27/1/2025 passed by this court was not complied with. And my lord, same page, my lord, paragraph 15. The last line, my lord, the last line, page 241, paragraph 15. Since admittedly, the aforesaid three witnesses were not earlier cross-examined by the writ petitioner for whatever reasons, it was incumbent upon the inquiry officer to comply with the directions passed by this court in WPC number so and so. Hence, the non-granting of a fresh opportunity of cross-examination of the said witnesses in the inquiry proceedings, the writ petitioner has totally contravened the principles of natural justice and fair. Then, my lord, there's one more material information that may be relevant, my lord. My lord, page 234, my lord, paragraph number 10. It appears that my lord, these are the options. Page 234, my lord, paragraph number 10. My lord, it appears that the respondent university, pursuant to the decision of holding an inquiry against the writ petitioner under Rule 7 and 9 of the Assam Services Discipline and Repeal Rules 1964, read with Rule 4 of the Gauhati University Conduct Rules 1975, submitted the memorandum of charges to the writ petitioner on 23/10/2024, along with a statement of allegation in support of the article of charges, including a list of witnesses by whom the article of charges is proposed to be sustained. Upon the perusal of the said list of witnesses, it appears that the following witnesses have been proposed to be produced as prosecution witnesses. My lord, the names are there, my lord. Subsequently, on 1/1/2025, after the inquiry officer was appointed, a summons was issued to the writ petitioner on 1/1/2025 requesting the writ petitioner to appear before the inquiry officer on 6/1/2025 in the venue and at the time mentioned therein, pertinent that in the list of witnesses enclosed with the said summons, the following 6 names are proposed to be produced as witnesses on that date. Now, my lord, paragraph number 11, next page. It appears that the names of Rafiqul Hassan Chaudhary and Singiram Mili, APS, appearing at serial number 3 and 4 respectively, were not earlier mentioned in the list of witnesses supplied to the writ petitioner. However, it is stated at the bar that Singaram Mili is the officer in charge of the ACP police station, SP Vigilance and Anti-Corruption, Assam, Gauhati, who was shown as one of the proposed witnesses at serial number 3 in the list of initial witnesses furnished to the writ petitioner. Admittedly, Rafiqul Hassan Chaudhary is not in the said list of witnesses furnished earlier in the point of time to the writ petitioner. Accordingly, on 6/1/2025, the writ petitioner submitted a reply in response to the aforesaid summons dated 1/1/2025 and sought time for postponing the inquiry proceeding to another date. The inquiry proceedings were accordingly adjourned to 16/1/2025. Thereafter, on 16/1/2025, the prosecution witnesses were duly examined and the statements were recorded in the inquiry proceeding. My lord, the subsequent paragraph would indicate that on 6/1/2025, the prosecution continued anyway. So, my lord, all of those circumstances and events that transpired, it gave a bona fide apprehension, my lord, for the appellant to approach this honorable court in the form of this writ appeal. However, my lord, if your lordship deems it not fit to sustain the scrutiny of your lordship, my lord, then at least I be given the liberty under 242 at page 242, my lord. That will be the only extent of my prayer which I am making. The lordship can very well dismiss the appeal, but at least the right which was granted to me by the learned single judge be kindly conferred to me, my lord. Subsequently, if I am removed, I may be removed, my lord. That will be a separate cause of action, but at least the right which was granted to me, my lord, I waited because out of utmost bona fide. My writ appeal was filed on 19/11. Within 30 days, there was no delay on my part. The matter came up in usual course. By then, it was already too late. That is the extent of my prayers, madam. My lord, the query, my lord, which was raised by this honorable court on the earlier occasion, was that since there was no specific allegation of bias against the IO, can the prayer made in the writ appeal be sustained, my lord? For that, my lord, I have brought in one judgment, my lord, as to how the pleadings need to be construed, my lord. That will be the extent of time. Paragraph 6, my lord, at page 562. My lord, paragraph 6, my lord. If I may, my lord. My lord. 6. The question which falls for consideration is whether the respondents in the written statement have raised the necessary pleading that the license was irrevocable as contemplated by section 60B of the Act, and if so, if there is any evidence on record to support that plea. It is well settled that in the absence of pleadings, evidence, if any, produced by the parties cannot be considered. It is also equally settled that no party should be permitted to travel beyond its pleading, and that all necessary and material facts should be pleaded by the party in support of the case set up by it. The object and purpose of pleading is to enable the adversary party to know the case it has to meet. In order to have a fair trial, it is imperative that the party should settle the essential material facts so that the other party may not be taken by surprise. The pleadings, however, should receive a liberal construction. No pedantic approach should be adopted to defeat justice on hair-splitting technicalities. Sometimes, pleadings are expressed in words which may not expressly make out a case in accordance with strict interpretation of law. In such a case, it is the duty of the court to ascertain the substance of the pleadings to determine the question. It is not desirable to place undue emphasis on form. Instead, the substance of the pleading should be considered. Whenever the question about lack of pleading is raised, the inquiry should not be so much about the form of the pleadings. Instead, the court must find out whether, in substance, the parties knew the case and the issues upon which they went to trial. Once it is found that in spite of deficiency in the pleadings, parties knew the case and they proceeded to trial on those issues by producing evidence, in that event, it will not be open to a party to raise the question of absence of pleadings in appeal. In Bhagwat Prasad versus Chandramal, a constitution bench of this court, considering this question, observed if a plea is not specifically made and yet it is covered by an issue by implication and the parties knew that the said plea was involved in the trial, then the mere fact that the plea was not expressly taken in the pleadings would not necessarily disentitle a party from relying upon it if it is satisfactorily proved by evidence. The general rule, no doubt, is that the relief should be founded on pleadings made by the parties, but where the substantial matters relating to the title of both parties to the suit are touched, though indirectly or even obscurely in the issues, and evidence has been laid about them, then the argument that a particular matter was not expressly taken in the pleadings would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such an objection is, did the parties know that the matter in question was involved in the trial and did they lead evidence about it? If it appears that the parties did not know that the matter was an issue at the trial and one of them had no opportunity to lead evidence in respect of it, that undoubtedly would be a different matter. My lord, this case law was in relation to the query which was posed by the Honorable Court, my lord, in the earlier occasion, that was there a specific plea regarding bias against the IO member? Since there was no specific allegations, but the paragraphs indicated the different actions taken by the IO at different points in time, my lord, I had brought in this judgment to satisfy this court, my lord, subject to this court's discretion, my lord. That is the extent of my case today, my lord, arguments today, my lord. If your lordship dismisses the appeal, in the worst case scenario, at least I'll be given the liberty to cross-examine, and if your lordship allows the appeal, my lord, I'll be grateful.
Lord, I take your lordship straight to page 219, Annexure B2. 219, 219, 219. The Gauhati University's written submission. First 2-3 pages, very much relevant to the entire proceedings. May I read? The writ petitioner during his service tenure at Bhattadev University on lien from Gauhati University as its registrar on probation was arrested on 6/8/2022 in connection with acceptance of bribe money of rupees 50,000 in front of a pre-trap team of Assam Police in ACBPS case number so-and-so under section 7A of PC Act 1988 as amended. After releasing from Bhattadev University with effect from 1/2/2023, the writ petitioner joined his parent university on 26/7/2024. And the same day, the writ petitioner was put under suspension. Thereafter, DP has been initiated by Gauhati University against the writ petitioner, issuing memorandum of charges on 23/10/2024, and having received a written statement of defense dated 4/11/2024, an inquiry officer was appointed. However, in the midst of the said DP, the writ petitioner moved WPC number so-and-so for according a legal practitioner as his defense assistant, which was dismissed by this honorable court by judgment and order dated 27/1/2025. Also inter alia directing that in the event the petitioner has not been able to cross-examine the 3 witnesses on 16/1/2025, the IO should, next page, 220, consider giving an opportunity to the petitioner to cross-examine the witnesses in the departmental proceedings. It is stated that in the said DP on 16/1/2025, the writ petitioner, that is the delinquent, cross-examined PW1, however declined to cross-examine PW2, PW3, and PW4. On 27/1/2025, the DP was held in the afternoon of 27/1/2025 as fixed earlier. Much after this honorable court's aforementioned judgment and order dated 27/1/2025 passed at 10:30 AM on that day, declining the assistance of a legal practitioner. However, the writ petitioner did not want to cross-examine the aforementioned 3 witnesses, though the writ petitioner was well aware of this honorable court's aforementioned judgment and order dated 27/1/2025, which was pronounced at 10:30 AM of 27/1/2025, regarding giving the opportunity to cross-examine them during the relevant period. And the writ petitioner even put forwarded his concluding statement that day itself. On the other hand, on 30/1/2025 at 4:52 PM, after long 3 days since the conclusion of the DP, the writ petitioner sent an email praying for cross-examination of the prosecution witnesses, just for delaying the process of the DP concern.
Next para. Afterwards, the inquiry report has been submitted on 13/2/2025 with a conclusion that a charge of misconduct is proved beyond any reasonable doubt, incorporating therewith 3 numbers of recommendations in this regard. Page 221, next page. Thereafter, the writ petitioner has been duly informed on 13/5/2025 that the inquiry report has been accepted by the Executive Council of the University, and the report has been forwarded therewith for his response within 7 days, which has subsequently been extended on 19/5/2025 for 5 additional days as per the writ petitioner's request. Afterwards, the university's Executive Council agenda dated 19/5/2025 has fixed the matter to be taken up at serial number 8 in a meeting scheduled to be held on 30/5/2025 for consideration of inquiry report dated 13/2/2025, as well as response thereto by Dr. Guru Prasad Khatani. Milord, these are the factual context of the entire matter, Milord. And regarding particularly that biasness aspect, Milord, the brief facts clearly show that there is no real likelihood of biasness on the part of the inquiry officer. It cannot be the likelihood of biasness. It should be real likelihood of biasness as propounded by Honorable Apex Court in various judgments. Milord. Milord, sometimes it goes to the arena of biasness, I admit. Milord, if anyone speaks something, Milord, always, Milord, some personal flavor, some sort of biasness is there. So, Milord,
Madam, this may be a material submission from my senior friend, madam. That the personal flavor might be there. The personal flavor might be there.
anytime,
Then, madam,
anywhere,
that might
not in the court proceedings,
madam. So
Milord,
there is a possibility, madam.
but it should be real likelihood. I admit, Milord, that rupees 50,000 bribe rings something somewhere. I agree. But I have not said that the writ petitioner, writ appellant has already moved 14 times, 14 petitions before this honorable court, last 2 years.
Not aware of 14.
I will give the list if so required. 14 petitions, including this writ appeal. 4 petitions against Bhattadev University and others.
Madam, কথা কৈছেন ভাই তোমাতে মিছা থাকাৰ মতে
কালিলে যিটো কৰিলে সেইটোৰ সৈতে মোৰ লিষ্টখন আছে লাগে যদি দি দিব পাৰিব মানে উইথ আই এইবাৰ
No, that's
then, Milord, the relevant legal aspects we can skip, Milord. Now, page 224. Milord, I think this relevant legal aspects, page 221, Milord, the second and third one, may I read, Milord? 1 onwards, relevant legal aspect. The inquiry officer could record his recommendations in addition to fate of the charges, and the disciplinary authority is not bound by the said recommendations. 2. Unlike criminal proceedings, DP does not require a high degree of probity, and some evidence, in contrast to no evidence, is enough to hold the delinquent guilty of the charges. In the instant matter, opportunity of cross-examination of 3 witnesses were asked for much later, that too after conclusion of the examination of witnesses concerned. 3. The court would not enter into the inadequacy of the evidence in the DP. Cross-examination is regarded, next page, is regarded as oral evidence as per the Evidence Act, unless it is perverse or of no evidence. 4. The delinquent is entitled for putting forward his response to the inquiry report after getting intimation about the provisional, tentative acceptance, or for that matter, non-acceptance or partial acceptance of the inquiry report, and the delinquent should not make any response if the inquiry report which proves charges is not accepted by the disciplinary authority concerned. 5. The DP is a continuous quasi-judicial process up to the stage of penalty imposed, if there is any, and there is alternative remedy available including appeal review provision even after the stage of penalty imposed. As such, prior to the appellate review stage, moving of any writ petition at any stage in the midst of the DP would be a premature one, making way for opening a floodgate of litigations, unnecessarily stalling the entire DP concerned, without even knowing the outcome of the DP, disciplinary authority's thought process or decision-making process regarding the aspect of imposition of penalty in the ultimate stage. Next, 6. The delinquent has asked for extension of time for making his response to the inquiry report, and at the same time has moved a writ petition before this honorable court. Next page below. Using 2 fora at the same time, which is not acceptable in the eyes of law and is regarded as a misconduct on his part. 7. The judgments of the coordinate bench, etc., as cited by the writ petitioner's side, are based on totally different factual metrics, those being in connection with post-DP and or post-appellate review stage, when everything is over after imposition of penalty concerned, unlike the instant matter. 8. Black's Law Dictionary, 6th edition, defines the word accept inter alia to receive with intent to retain. In the instant matter, the post-accepted Executive Council's Agenda number 8 dated 19/5/2025, which meeting was held on 30/5/2025, clarifies that the disciplinary authority accepted the inquiry report in provisional tentative manner only.
The resolution, page 97. 97.
Annexure U.
Make sure you assume that. Yeah, I got 97. I got it.
Para 8 clarifies that the disciplinary authority, last 3 lines, accepted the inquiry report in provisional tentative manner only, and thereafter sent it for response of the delinquent. So the acceptance of the executive council, the disciplinary authority, is in provisional tentative manner, my lord, and it has sent the inquiry report to the delinquent for response. So final decision has not been taken at that stage. 9. There are provisions for preferring appeal review petition if the delinquent is aggrieved with any of the orders, including penalty imposed made by the authority concerned at the end of the DP under Rule 13, 15, 16, 27 of the Assam Services Discipline and Appeal Rules 1964 to be read with Rule 51, 53, 61, 62 of the GU Employees Service Commission Conduct and Appeal Rules 1970. Next page. The citations, my lord.
My lord. Hello. My lord. Yes, ma'am. Page 20, what do you call, if you allege bias, then the party concerned has to be the party and then
Indicate
heard.
by name, my lord. Indicate by name, my lord.
That is not there.
My lord.
Then the hearing would be futile exercise.
No, in fact, my lord, if your lordship kindly looks at page 39.
Here,
Yes, my lord,
you
the
see
prayers,
that-
my lord.
well,
The prayers had sought for setting aside of the entire DP, and once that DP goes, my lord, the involvement of the IO also goes along with it. Now, that was the prayer, the overreaching prayer and belief that we sought from this court. And this court, my lord, in its wisdom, had granted us, had partly allowed the petition, pursuant to which, my lord, the writ appeal has now been founded on the aspect of bias, because bias, as has been laid down, my lord, was pleaded in the facts which was stated in the writ petition, and thereafter, my lord, an endeavor was made to impress upon this court before the learned single judge that the DP ought to go. My lord.
yes, Mr.
My lord. Page 224, my lord.
Page
224. The citations. I shortly indicated the main theme of those judgments. You know. My lord, 1. State of Gujarat versus RG,
you know
Then-
that.
my lord.
you
The
know
inquiry
the
of,
citations.
my lord.
You may omit the citations, since it is there, we'll go through it.
My lord. Particularly, my lord, this Kuldeep Singh judgment, next page, my lord. Page 225. Serial 6, my lord. The 99
Six.
judge. Serial 6, page 225.
Here.
Kuldeep Singh case, my lord. Interference of court arises when there is no evidence and or perverse finding. If there is only one evidence in the DP, then, my lord, the court doesn't interfere. And there are numerous cases, my lord. So, my lord, that was the written submission before the Honorable Single Judge, my lord. And accordingly, my lord, in the last page, my lord, the impugn judgment, my lord, the delinquent writ petitioner has been allowed to cross-examine 4 witnesses. And by a letter dated 2011-2025, I have not annexed which an affidavit, my lord, as yet. He has been directed to cross-examine those 4 witnesses, my lord, as per this honorable court's order. But his plea was that he has filed a writ appeal. No stay order was granted. And in spite of that, my lord, my lord, he did not participate in the said cross-examination process, my lord. And thereafter, my lord, inquiry report has been submitted. Executive Council, being the disciplinary authority, took the decision. He has been terminated on 26th to 22 February 2026.
Thank you.
20 February, madam.
20 February.
Additional affidavit, madam. Page 277.
Please give the dates of, relevant dates after the date of, after the writ petition order.
My lord.
Sequence of events is,
My lord, if your lordship kindly takes up, the dates are given, I have prepared an index also, the additional affidavit, madam, to bring on record all the subsequent events, madam. Starts from page 251.
251.
251, my lord. 251 was the summons.
Just
My lord.
and what is the date of that single judge's judgment?
My lord, single judge's judgment is 4/11/2025.
4/11/2025.
Yes, madam.
Yes.
The summons then were on 14/11/2025, inviting me, my lord, to attend the cross-examination to be held on 21/11. I responded on 2011 stating that a writ appeal has been preferred and it has not yet been listed. The filing number was also indicated, my lord. Then, my lord,
Just a moment.
my lord.
Yes.
250. Then, my lord, against the summons dated 14/11/2025, I replied on 20/11/2025, which my lord will find at page 252. 252, my lord.
Yes.
Then pursuant to that, on the very same day, my lord, they came back with a response at page 254.
This is very vital, my lord. One day before that cross-examination process.
Then, my lord, at page 255 is the intimation of the inquiry report. Now, this inquiry report is similar to the inquiry report which was already set aside because, my lord, I was not given the opportunity to cross-examine, and even in this occasion, I have not had the occasion to cross-examine. Page 255, my lord, 2012-2026 is when the inquiry report was intimated to me. Then, my lord will find at page 276, where I said, my lord, my lord, my lord. Now, my lord will see a date, my lord, which might be very relevant or which might be out of place. My lord, my senior friend can clarify. 256, page 256, my lord.
This 256 is that report.
The report, my lord. The lordship will see the topmost heading, my lord. Index of the findings of the departmental inquiry drawn up against Professor so-and-so under suspension, Gauhati University, wide reference number dated 23/10/2024, my lord, which is the date of the memo of charges, and GUST SO dated 13/11/2025. But 13/11/20, I was given the summons on 14/11/2025. Now, what had transpired on 13/11/2025, my senior friend may be able to clarify before this court. Either it's a clerical error or the inquiry had already been commenced behind my back, and 13/11/2025 is the date of the inquiry which they've stated, and the summons was on 14/11, which was immediately the next day.
So that is already there in page 256.
My lord, 13/11,
13/11 is the date given in serial number 12.
my lord,
Serial number 12.
my lord. Intimation to the IO dated 13/11/2025. But here, my lord, true, my lord, true. Then at page 276, my lord, is my response to the inquiry committee report, my lord.
Yes.
My lord, 276 is my reply, my lord, which is dated 19/2, that I've restated, my lord, that the appeal is still pending, and my lord, I'd like to submit on oath, my lord, that there was no defect in the appeal. There was no defect in the appeal, my lord. The appeal was listed in regular course, my lord. And then 277 is on 20 February 2026. I was removed. 22/2026, my lord, at page 277, I was removed. $278, my lord, is the advertisement for the post of registrar. 278, my lord. It is dated 23/2/2026.
Take a short break and come back.
My lord.
Yes.
My lord, regarding the biasness aspect, my lord, since the entire writ appeal is revolving around on that aspect, my lord. So, my lord, I beg to place one judgment, 2001, 1 SCC 182.
2001.
2001, volume 1, SEC, page 182. Paragraph Paragraph 10, may I read, my lord? Paragraph 10. 10, 11, 19, 34, and 39. Paragraph 10, page 190. Very.
Yes.
The word bias in popular English parlance stands included within the attributes and broader purview of the word malice, which in common acception means and implies spite or ill will. Through Judicial Dictionary, so and so. And it is now well settled that mere general statements will not be sufficient for the purposes of indication of ill will. There must be cogent evidence available on record to come to the conclusion as to whether in fact there was existing a bias which resulted in the miscarriage of justice. 11. While it is true that legitimate indignation does not fall within the ambit of malicious act, in almost all legal inquiries, intention as distinguished from motive is the all-important factor. In common parlance, a malicious act has been equated with intentional act without just cause or excuse. Now we can skip other paragraph, Miller. Paragraph 19. Paragraph 19, page 195. Down below. Paragraph 19. While it is true that in a departmental proceeding, the disciplinary authority is the sole judge of facts and the High Court may not interfere with the factual findings, but the availability of judicial review, even in the case of departmental proceeding, cannot be doubted. Judicial review of administrative action is feasible, and the same has its application to its fullest extent in even departmental proceedings, where it is found that the recorded findings are based on no evidence, or the findings are totally perverse or legally untenable. The adequacy or inadequacy of evidence is not permitted, but in the event of there being a finding which otherwise shocks the judicial conscience of the court, it is a well-nigh impossibility to decry availability of judicial review at the instance of an affected person. The observations, as above, however, do find some support from the decision of this court in the case of Apparel Export Promotion Council versus A.K. Supra, 1999 case number. Now, we can come to the para 34 and 35, the last page, below, page 201. Para 34. The Court of Appeal judgment in Lekabel case, though apparently as noticed above, sounded a different note, but in fact, in more occasions than one in the judgment itself, it has been clarified that conceptually the issue of bias ought to be decided on the facts and circumstances of the individual case. A slight shift undoubtedly from the original thinking pertaining to the concept of bias to the effect that a mere apprehension of bias could otherwise be sufficient. Now, paragraph 35, it is important.
This, incidentally, we will tell you this Lokabal case is one of the cases which puts the judges to seclusion. In this Lokabal case, the fact was that the question was whether the judge knew that member of the public, and therefore likelihood of bias. It is in order to save ourselves from this bias that we stay indoors.
The 1955 All England report.
Just telling you, this, not that is this judgment is not the basis.
Miller.
But the issue raised in this Blocker case, this was a case of UK.
UK. Miller.
So that principle we follow.
Miller.
Because if there is mingle with the public,
Miller.
likelihood of bias, that very kept safe.
Now, paragraph 35 Miller. The test therefore is as to whether a mere apprehension of bias or there being a real danger of bias, and it is on this score that the surrounding circumstances must and ought to be collated and necessary conclusion drawn therefrom. In the event, however, the conclusion is otherwise inescapable that there is existing a real danger of bias, the administrative action cannot be sustained. If, on the other hand, the allegations pertaining to bias is rather fanciful and otherwise to avoid a particular court, tribunal, or authority, question of declaring them to be unsustainable would not arise. The requirement is availability of positive and cogent evidence, and it is in this context that we do record our concurrence with a view expressed by the Court of Appeal in Lucabel case. Regarding biasness, Lord, I think this judgment will be sufficient. And regarding that perverse finding or no evidence aspect, this Kuldeep Singh judgment, Lord, may I please, Lord? There are 6 to 10. 1999, 2 SSC, page 10. Kuldeep Singh versus Commissioner of Police and others.
Don't read this.
Miller.
We'll take note of that.
Miller. Para 6, 7, 8, 9, and 10. If there is only one evidence in the entire departmental proceeding, it is enough. And this honorable court only interpreted regarding bias, Miller, that Kumon judgment. It will be seen, but Kumon. No. Most of it.
Yes, Mr. Sharma, you reply.
My lord, my senior friend had relied on the judgment of 2001, 1 SCC 182, my lord. I'll start with paragraph 34 only in the judgment, my lord. That the Court of Appeal judgment in Lokabile, though apparently as noticed above, sounded a different note, but in fact in more occasions than one in the judgment itself, it has been clarified that conceptually, the issue of bias ought to be decided on the facts and circumstances of the individual case, a slight shift undoubtedly from the original thinking pertaining to the concept of bias to the effect that the mere apprehension of bias could otherwise be sufficient. The facts and circumstances of this case, my lord, leads us to 4 pointers. The first pointer being that the letter dated 30/1/2025, which was preferred by the petitioner before the inquiry officer, claiming a right to cross-examine the witnesses, was rejected. Second, 351 of 2025, my lord, the earlier petition, W 351. Date 31/2025. That prayer for cross-examination of the witnesses was rejected implicitly without there being any consideration on the part of the IO. That is my first consideration. The second instance that might be relevant for this honorable court,
30 January 25.
30 January 25, my lord. That has been recorded in the judgment of the learned single judge, my lord, that there was a liberty which was granted. The matter pertaining to my defense assistant being a lawyer, my lord, that matter was decided on 27/1/2025. pursuant to the liberty granted by this honorable court, I preferred the letter dated 31/2025, praying that I be permitted to cross-examine the witnesses. That prayer was rejected impliedly. There was no response from the IO on that count. Secondly, as the Honorable Single Judge's order indicates, that the list of witnesses were changed at the last instance without having there being a mention of those witnesses in the memorandum of charges. Secondly, reading both the surrounding circumstances together, the inquiry officer, who is an IPS, also having a degree in law, proceeded to recommend my dismissal from service, exceeding the mandate under Rule 6 of the Assam Services Disciplinary Rules 1964. The executive committee, while the resolution dated 13/5/2025, had accepted the inquiry report, but that aspect has been taken care of by the learned single judge, and the matter has been remanded to the stage of cross-examination. Now, the subsequent events will also indicate that there was a prayer from my side, from the appellant, on 20/11/2025, in utmost bona fide, stating that there was a writ appeal which has been preferred by the appellant, and you kindly stay the entire proceeding that it envisaged, and subject to what the Honorable Division Bench of this court directs and mandates, I shall be at your disposal. The disciplinary authority proceeded nonetheless in the absence of my cross-examination on 21/11/2025, and thereafter the inquiry report, which was prepared in the absence of my cross-examination, and I was directed to prefer my response, which again I reiterated that the appeal is yet to be listed. The appeal, there has to be a categorical finding, and the IO thereafter proceeded. In any case, my lord, on 22/2026, I was removed, and on 23/2026, my lord, there was a post for advertisement, which was an advertisement just floated for the post of registrar. Now, all of this situation, my lord, indicates that the learned single judge's order was 4/11. The summons was 14/11. There was haste which was shown by the departmental authorities, my lord. It may not find sustenance in my pleadings, my lord, but there was a haste to come to a conclusion pertaining to my future as a registrar of the Gauhati University. And if I had participated, my lord, I would have waived my chance to contest that before the Honorable Gauhati High Court. And that was the reason I had pleaded, my lord. I had stated the filing number, that I had preferred an appeal. There was no defect to the appeal. The appeal was listed in due course. My submission was on the basis that if the inquiry officer stays the same, bearing the procedural corrections, I may not be entitled to any new relief. But even if that does not find prominence before this honorable court, in my utmost humility, my lord, I pray that at least the liberty which was granted to me by the honorable single judge be granted to me. In fact, my lord, I had also appended a judgment of the Honorable Supreme Court on the aspect of bias, my lord. And your lordship would kindly come, if your lordship so permits, my lord, page 180 of the writ appeal, my lord. Writ appeal, page 180, my lord. 180, my lord. Krishna Dutt Avasthi versus State of Madhya Pradesh and others, my lord. The judgment starts at page 178, my lord. And the relevant portion is at page 180, paragraph number 19, my lord. It starts at 18. In the case at hand, the appellants countered the findings of collector, commissioner, learned single judge, and the division bench on the ground of violation of audi alterum partem. It was contended that the appointment was cancelled without joining them at an initial proceeding before the collector. The principle of natural justice does not solely depend on audi alterum partem. It needs to be prefaced by an action of the administrative or quasi-judicial authorities in the courts of common law jurisdiction in India to invalidate the orders based on rule of principle doctrine. The principle of natural justice emphasizes the basic values which a common man cherishes throughout. The said principle is based on rules relating to fairness, reasonableness, equity, and justice, good faith, and good conscience. It gives assurance of justice with the intent to develop confidence in the justice delivery process. The English law recognizes two facets of natural justice, My lord, 179, my lord. Chairman, yes, my lord. My lord. The entire, my lord. Bias. Yes, my lord. Yes, true. The perception, my lord. Perception. In fact, my lord, if your lordship had correctly talked about the, I see. My lord. 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 True, my true. My lord. But assume that. My lord. I'm moving it. My lord. I'll not. Now, my lord, dictation of the judgment. If it was the only isolated incident in the entire, my lord. My lord. Yes. True, my lord. True. True. Yes. 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 Yes, my lord. No, true, my lord. No. No, I understand. I understand, my lord. In fact, the urgent. 179, my lord. Yes. In fact, the entire finding in Krishna Dutt, my lord, is, as I understand, stems from the table at page 179. The proximity of the panel members, the committee members with the candidates. Now, to substantiate, my lord, what this honorable court had also said, what the honorable Supreme Court had also said, that when I talk about likelihood, my lord, it might not relate to a material happening of the event, my lord. It's likelihood, my lord. It may happen, it may not happen. Even in something may not happen, may your lordship look into the aspect of surrounding circumstances. The inquiry officer, it was very correct that the inquiry officer was absolutely unbiased. but in his understanding of the law, of his earlier 4 events which have transpired, which have led him to carry on the investigation in my absence and thereafter, on 14/11 to immediately come and not pay heed to my letter stating that there is an appeal. If all of those events were isolated and the other events had not taken place, then maybe, my lord, I would not have stood before this honorable court. Now, even if your lordship directs me to appear before the same item, I'll do that, my lord. This is my last throw of the dice, my lord. I held the post. I have been stripped of it, right or wrong. That is not in dispute, my lord. The authorities are correct under the law to proceed against me. But the mechanical manner of their proceeding against me, without having taken note of my earlier representations, that has led me to approach this honorable court. And if your lordship decides that the authorities were correct in proceeding, my lord, at least then I'd be given a chance to cross-examine. My lord, that is the extent of my prayers, my lord. I understand, my lord, I'm standing on very thin ice, but that is what it is, my lord.
Don't get disheartened, you have argued well.
My lord, I understand, my lord. But
Lord, may I point out one crucial aspect of this writ appeal? My lord, one thing, my lord, that biasness aspect is there, but he has not been, my lord, personally, my lord, completed. But one thing, my lord, the writ appeal has been filed on 19th November.
yes,
Cross-examination was held on 21 November. He filed a writ appeal, but left unattended till 3
No,
months.
that's not, they are not unattended.
My lord, objections were raised by the registry on 28/11/2025, and those objections were complied on 20 February 2026. After near about 3 months,
this information has been given. Sorry, it is really.
as per the, my lord, filing history of that writ appeal. I have just gone through the 20 February 2026. After long 3 months, those objections were
Appeal.
this
Present
writ
appeal.
appeal. Filed on 19 November, objections were raised by the registry on 28 November, immediately after 9 days, and left unattended till 20th February 2026, near about 3 months. Then this matter has come up before court number 1
193.
on 9 March 2026.
No, because,
Secondly.
because, my lord, there was no material defect on our part. What might have entailed was a communication from the registry to may have a photocopy of the certified copy of the order which we have appended since the division bench matter. But that was never communicated because I had just submitted before this court on oath, my lord, that there was no defect on us. We were not meant to attend this writ appeal after we filed it. This is what we understand, my lord.
And
Here
honorable,
there are 5 objections. Filing forms to be filled up. Number 2, second page of the index be stitched in proper place. 3, no original certified copy. 4, a copy of the interim judgment is also annexed in part 2 file just below the index. Certifying the annexes, the pattern is original, not Xerox copies.
Then I'll leave it to your lordship. Then if it's a
Please,
based on my lord, I'll leave it.
No, we are not.
I apologize, my
more
lord.
bothered on that. We are not more bothered on that because that is a mishap which happens.
I apologize, my lord. I deeply apologize.
No, it's
No.
it happens because
Sorry,
we don't take much on that because this is something we have also faced.
No, true, my lord. But since there was urgency, the onus was on my part, my lord, to have ensured that, my lord, I made a wrong submission. I apologize, my lord.
an earlier occasion, my lord, the honorable division bench, my lord, indicated that it is cul-de-sac for you, my lord.
The cul-de-sac, my lord, I have reached a point in the road
That
where
means
there is no respite, my lord. At least
dead end. regarding that-
cul-de-sac is not a dead end, my lord. If I have a good car, my lord, I can cross. So the only yes, the grace that I need from this
What
honorable
is the term?
cul-de-sac. It's
CULDESAC.
CULDE-SSC. It's a French word. cul-de-sac, man.
It's a cul-de-sac for you.
But the Honorable Court, my lord, did not have an occasion to go through the additional affidavit, which was filed subsequently, my lord, to bring the recorded events. So the court could not, my lord, my submission.
Obliged.
Rosmin has it. Appellate, my lord. Two o'clock, 22:05, my lord. To tomorrow, my lord. I'm grateful. 24. My lord, whenever your lordship deems it desirable, my lord. Whenever your lordship deems it desirable, the lordship is good.
Most problems.
My lord. My lord.
For hearing, item 7, WBC 392/24.
Already started.
Item 8, item 8,
Lordship in 8, do not really appear, however, Lordship, some status report we have. Yes.
Item 9.
And again, Lordship, denied to appear.
Item 10.
My lord, as per order dated 22/10/2024, lordship, while going through the records, I have found that prior to that, I have found that annexure A is missing. That means the LGO's report, and which was also reflected in the order dated of the Honorable Court, lordship, 22/10/2024, to ascertain, because otherwise it's an incomplete report, lordship. Annexure B is there, ERO's report is there, but ERO's report is based on LVO's report. So main inquiry form is missing in the report. Whereas annexure B, 2 copies are there. Page number 10 of the record, lordship, yellow flag mark is there. Yes, lordship. But annexure A, which is the LVO's report.
Lordship, actually, I am not recollecting now, Lordship, whether it was. Lordship. Yes. Yes.
LVO
Yes,
inquiry,
yes,
and ERO forwarded it.
Yes, Lordship.
Yes, lordship. Sarvan.
Yes.
Never challenged at the stage of the proceedings, and therefore in a writ petition, when we are exercising statutory jurisdiction, that would not be an aspect where we go through. But still, you will find out.
Lordship.
He is pending as an amicus curiae to the court. No, first.
Yes, I have seen Lordship. I could not find Lordship.
You need to send it to make an inquiry whether in the SP office,
Yes,
when they are sending it, whether it is available or not.
Lordship.
And every likelihood of the document not being there would be, the mistake is that 2B is here, therefore 2A must have gone somewhere. And now it went to the IMDT. After IMDT, the records have come. So, and the page continuity is there. Therefore, it was never there in the tribunal. Therefore, it can't be now traced out. That is the possibility. So still find out. This big host, amicus curiae, has referred to the order dated 22/10/2024 and has submitted that the LBO report in form of annexure A is not available, and the record contains two forms of annexure B of the LBO report. Next one. The Mr. G. Sharma, understanding of for the FTL order matters. Phase 1 is granted 2 weeks time to ascertain the existence of annexure A part of the LBO's report. LBO after that. Next one. All other respondents are represented. Next one, list on to a date after 3 weeks.
Lordship, these two cases are.
You need a copy. Sorry, yes. Put that last time in place. To facilitate the done standing also for the FTL border matters. The court counsel shall provide photocopy of, that is page number
Page number, Lordship.
8 and 9 or 9 and 10.
9 and 10, Lordship.
Page number 9 and 10.
9 and 10.
9 and 10 of the ACS. Of the fabulous record. The done standing also for the FTL border matters to enable him to make the inquiry. Next one, the learned standing also for the FTL border matters is permitted to send a downloaded copy of this order to the competent authorities to enable him to get instructions.
Yes. Lordship, item 10, if possible, Lordship, can it be on day after tomorrow, Lordship, item 10? Sorry. Yeah, 10 next item, Lordship. 11. Sorry, is there, Lordship.
I am tell number 11. I am ready with that.
Day after tomorrow, Lordship, because I want, actually, I could not able to see the file, Lordship.
Next Tuesday, my lord. Next Tuesday,
If possible, Lordship, day after tomorrow,
day after tomorrow.
Yes, yes. Lordship.
My lord.
Time being item 4 for admission.
I'm sorry, my lord, in the first half, I could not. Well, the lordship is taking up the matter after some time, my lord. Just I'm refreshing. I was testing my case, my lord. But lordship may kindly take up the repetition. Just
just to refresh, my lord. My lord, this is the case of no, this is not Runi Khata. This is from Kachar, my lord. This is from Kachar. Runi Khata is item number 8, item, no? Item 8. This is Katigora PS case 291 of 12. Yes. Malak. Malak. Now, Malak, Malak. Malak, that is the additional affidavit filed by the petitioner. Page number starts at Malak, page number 99. The affidavit starts at page 99. Malak, just to refresh, Malak, my submissions. Malak, the petition was filed. Yes, logical, notable. From that stage, I stop on that. But here, Manoj, my submission is with the petition has 4 prayers. Number 1 is inquiry by CBI or NI. Second is Manoj, departmental proceeding against the police. And then Manoj, the submission, the death certificate and the submit death certificate and the postmortem report. This was not there. Yes, sir. CBI inquiry. Mother. CBI inquiry or by NIA. And the absolutely. Sir. Yes, ma'am. Yes, yes, ma'am. So in the logic. So ma'am, the submission of death certificate and the PM report, that prayer is no longer is required to be decided because the death certificate PM report is already given. Only lordship will examine this case regarding the whether any further inquiry by CBI or the NIA that prayer remains or the compensation part, adequate compensation. So I took lordships to the affidavit, the additional affidavit at page 99. There, some paragraph I have referred. But in this affidavit, now by filing this affidavit, they are relying on the statement of paragraph 3 I have read and statements of 3 witnesses they are referring now. So annexure B to this affidavit, that is at page 110, that annexure B is the inquiry report under 176 CRPC. This report is important because the witnesses were examined, witnesses were recorded, the statements were recorded in this inquiry only, if they are referring to this. Only page number 110, annexure B of the additional evidence. Lordship, kindly take up the annexure B, the inquiry report. The relevant, kindly come to page 111, para 6. During the inquiry, the following witnesses are examined on different dates. Name of witnesses 1, 2, and 3. These are the three witnesses. Now they are referring and relying on that they are the eyewitnesses of committing their particular injury by the police officer. Logic. So paragraph 8, the statements were recorded. I'll read some of the paragraphs from this report. This report is important because they are relying now. The case is in the repetition is different, in the additional affidavit it is different, and they are taking the statements from this report. So the paragraph 8, statements of the persons examined during the inquiry. The witness Mohibur Rahman, alias Moyur, stated that on 6/7/2012 at night at around 1 a.m. he heard cries in the house of the neighbor Azizur Rahman. He woke up and went to the house of Azizur Rahman. He was informed by the gathering that about few moments earlier, 5 policemen took away Azizur Rahman after assaulting him. As there was curfew in the area, he along with Tajuddin and Shahiduddin went towards the Kalain police post by a village road. Then they set towards the western side of the post near a pond. They saw that the police set Ajijur on a red plastic chair and arguing with him. Suddenly, 2 police held the legs of Ajijur and 1 tribal police officer held the head and face of Ajijur and gave a jerk. Then Ajijur fell towards right. After 4 or 5 minutes, police took Ajijur by a vehicle. Later on, he came to know that Ajijur died. He informed the family members of Ajijur. I am trying to show contradictions, and there's a lot of contradictions are there. The statement of these 3 witnesses, which in the additional affidavit they are now trying to rely. I am trying to persuade that these statements as it is cannot be taken because there are a lot of contradictions. But he informed the family members of Ajijur. So whatever he has stated, he said that he is informed. He has informed the family members. Then Tajuddin Borbuya, also in the similar line, he said that Tajuddin Borbuya said that on 6/7/2012 midnight, Mohibur came to the house and called him. He was informed by Mohibur that police has taken Ajijur to Kalain police post. Then they went to the house of Asaduddin. They could not find Asaduddin and informed the incident to Shahiduddin. Thereafter, all of them went towards the Kalain police post and stood near a pond in front of the post situated near a house. Then they saw that the policeman and Ajijur engaged in altercation. They saw that Ajijur was sitting on a red plastic chair. Suddenly, they saw the 2 policemen held both the legs of Ajijur. Then a tribal police officer held the face and head of the Ajijur by both the hands and gave a jerk. Then Ajijur leaned towards the right. Then 2 policemen took Ajijur to a vehicle. On the next day, they come to know that Ajijur died. Then Shahiduddin also, he said that Mohibur Rahman and Tajuddin called his brother at around 12:30 at night. At that time, his brother Asaduddin was not in the house. He came out and he was told by the 2 that Ajijur was taken to Kalain police outpost. Then they went towards the Kalain police outpost by a village road and stood opposite the post near a pond. He saw that Ajijur was sitting in the armchair and the policeman altercating with Ajijur. Then 2 policemen held Ajijur by the legs, and then a tribal policeman held Ajijur by face and head and gave him a jerk. Ajijur leaned and fell down. After 4 or 5 minutes, the 2 policemen took Ajijur by a vehicle. Then Mohibur informed the family members of Ajijur. On the next day morning, they could come to know that Ajijur died. So these are the statements. All of them have said that the policemen have given him a jerk. Lordship, we kindly come to the all of them have said that Mohibur is the person, he has informed the family members of Azizul about what has happened in the police station. And Malad, the kindly the dates are very important. The incident took place in the intervening night of 6th and 7th of July at around 12:30. And the FIR was lodged on 8/7/2012 at 5:30 p.m. in the evening. And according to their statement, Mohibur informed them about what is happened. PW, witness number 1. He informed the family members. The information which now he is deposing before this inquiry is so important, Malad, that if it is assumable, he had informed this in the FIR, Malad, which is filed in the next day evening, definitely, Malad, they should have mentioned it, Malad. In the representation also filed few months back, after the incident, Malad, after a few months, they have filed a representation. That is also, in that also, Malad, they have not informed that mention anything of that sort. Now, kindly Malad, come to page 114. These are Malad, my respectful submissions, Malad, these are afterthoughts, Malad. These are during the, Malad, these statements were taken on 30th of July. On 7/7, the incident took place, 8/7 FIR file. On 30th of July, the statements were taken. These are afterthoughts. They have developed this story, Malad. Then kindly see, Malad, the materials available on record. This has been Malad, stated by the officer, the doctor, associate professor, Department of Forensic Science. Page 114, Roman 6 is there, Malad. On 27/9/2012, Dr. Gunojit Das, Associate Professor, Department of Forensic Science Laboratory, SMC Silchar, was examined. His statement is summarized below. His statement is relevant, Malad. He has done the postmortem of the deceased Azizur Rahman in connection with GG entry number 125 dated 7/7/2012 of Gungur Police Outpost. After completion of postmortem examination along with videograph of entire procedure, the viscera of the deceased was handed over to the accompanying police constable for onward submission to the Forensic Science Laboratory, Gauhati, through proper channel for chemical, toxicological analysis. The provisional report was prepared with all the findings of the case, keeping the information as to cause of death pending till receipt of the report of chemical analysis of the viscera from FSL, and the same was handed over to the concerned police station. As the report not received by the department, he is unable to submit the final report as to the cause of death of the deceased, Azizur Rahman. Dr. Gunojit has stated that a detailed postmortem examination is carried out in all cases sent to his department for medico-legal postmortem examination, and the whole body in respect of presence or absence of any injury or disease is dissected, and what is it has not come in the photograph. Then opinion is framed on the basis of the findings not during postmortem examination. In respect of Azizur, also the standard procedure and all the necessary steps were followed in carrying out the postmortem examination. Entire procedure starting from identification of the dead body up to the handing over of the dead body to the police constable for postmortem. The video filming is done. The video cassette was handed over to the accompanying police constable. With this portion, we can skip. We can come to little in the middle. The X-ray cannot also tell the X-ray part. After two lines, we can start. He further said that taking X-ray of the dead body before postmortem examination is not standard procedure, as the requirement of X-ray comes when there remains some doubt in the mind of the autopsy surgeon or doctor doing the postmortem examination regarding presence or absence of any finding, which can be seen only on the X-ray. In terms of any injury, X-ray are advised or can be done when after extensive dissection of the part, there remains a doubt in the mind of the medical officer regarding presence or absence of an injury in the part. X-ray can also be advised in the case of any doubt regarding the presence or absence of a foreign body, which could not be ascertained by extensive dissection of the part. Moreover, one basic drawback in doing the X-ray and to opine in any postmortem examination from X-ray, the doctor cannot opine whether it is antemortem or postmortem injury. X-ray cannot also tell any dislocation or joint or bones as to it is antemortem or postmortem nature. The dissection of the part in detail is mandatory to opine both presence and absence of injury in the bones, and also it is antemortem or postmortem nature. In case of Azizur Rahman, the whole body was dissected and he did not find any necessity to go for X-ray of any part as he was confident enough in his dissection and also in the finding the absence of any injury in the bones. In the postmortem report, he has mentioned that no ligature mark was present in the neck. The allegation in the affidavit is now that a jerk was given. So if such a the jerk is given, and as a result of that, the person died, some mark will be there in the neck because the statement of the witness is that jerk was given and ultimately his the head leaned in the right side. So the doctor said, yes. No, I'm coming. In the tissue also, some pressure, something will be there, Malak. I'm no internal tissue injury will be there, Malak. If pressure is given, Malak, if force is used, at least some deformation, Malak, in the internal deformation will be there, Malak. That Malak, the doctor has said. Kindly come, Malak. Lordship. In the postmortem report, he has mentioned that no ligature marks were present in the neck. But ultimately, someone has to, by two hands, the head has to be whole. It has to be with a force. It has to be done with a force, Mala. Not, I'm just coming, Mala. Lordship. In the as Lordship. But just I'm coming, Mala. I'm coming. Lordship. But in the postmortem report, he has mentioned that no ligature mark was present in the neck. He has not found any injury, disease or deformity, fracture and dislocation in muscle, bones or joints. When the doctor was asked in the inquiry that whether after postmortem fracture of any bones can be detected, the doctor said that finding of fracture or any other additional finding depends mainly on what sincerely the particular doctor who carried out postmortem examination during the examination. He said that he applied his best ability and knowledge and carried out the examination and with dedication and utmost sincerity with confidence and confident enough that there is no chance of getting injury or any other additional finding if X-ray is done. When a doctor is asked, is there any chance of getting fracture of neck bones if X-ray is done after postmortem examination, the doctor said that the chance of getting fracture is very negligible or almost nil. The doctor said that still photography was also taken along with the videography. So the doctor who has conducted postmortem report, my respectful submission is that he did not notice any deformity, my lord. In the leg, he said, specifically he said that he did not found any injury, disease or deformity, fracture and dislocation in the muscle bones or joints. Then kindly come to the next witness, Dr. Suman Bhumi. He also malad, said that on malad, no, photograph is not available. Photograph is not available. They said that they should have it. And where is that inquest report? Let us see the inquest report first. Which page is that? Inquest report. It is the postmortem. Where is the case diary? May I be there? You got it. Is that page 14, 15 of the FIR? Sorry, police records. Yes.
Please 134 people mark off the claims. 130 per pack. Tin number 11, tin number additional evidence. Last 132. Okay. Second election. First election. It will 2020, 29 election.
So we could be now, yeah, it's not a problem. But, the evidence of Dr. Suman Bhumik at page 116, serial 7, Roman 7. But, on 8/10/2012, Dr. Suman Bhumik is examined. His version is summarized. He is working in the Kaline FRU since the year 2001. He was brought with him the register of the hospital containing entries since 4/11/2011 to 7/7/2012 at 1:50 a.m. On 6/7/2012, he was in the emergency duty, and Srimati Romila Chakraborty, staff nurse, was also in the emergency duty. As per register brought by him, Azizur Rahman was brought to the hospital at 1:50 a.m. During arrival of Azizur Rahman, he found Azizur gasping. The pulse was feeble, BP not recordable. He observed the patient and gave him injection Dexona. Dexona this is a steroid. No? Ultimately, Dexona is logic. So it is one of the basically the person who suffers from some breathing problem or something. To them also it is given. So he gave the injection Dexona. He tried to improve the condition of the patient. He noticed that the condition of the patient is serious. Without wasting any time, he referred the patient to Silchar Medical College and Hospital. At 2:15 a.m., the patient left the hospital. Dr. L. Soikia, Deputy SP, so-and-so, Kachar, YT Getsu, IPS probationer, and other accompanied the patient. When he was asked, this is important because they are raising doubt now. When he was asked for comment that there is some deletion of writing about the report of Azizur Rahman in page 194 of the register, he said that he has no idea why there is deletion. He has not seen sign So he said, he has not seen sign of external injury on the person of Azizur Rahman. No family members of the patient accompanied to hospital. There is ambulance service in the hospital. At that time, oxygen was not available in the ambulance. There was no time to wait and call for an ambulance having oxygen facility. By vehicle of police of Kaline, the patient was sent from Kaline to Silchar Medical College and Hospital. During his duty period on 6/7/2012 at 11:50 a.m., he examined one cardiac so I am referring to this at that point of time, because in paragraph 6 of this affidavit, at page 102, now the statements have been made that although the victim was sent by to the SMCH by pretending him as alive, but he was sent to this SMCH in police vehicle and not by hospital ambulance, that too without giving him oxygen facilities, since they were very much aware that the victim was no more alive. These are all new statements coming up, developments coming up in the additional affidavit, paragraph 6. The doctor in his evidence has specifically said why he was sent in the police vehicle and not in the ambulance, because he said that there was no time to wait for that. So they have now doubt has been created. Moreover, on the relevant point of time, ambulance facility was available in the said hospital, and therefore non-providing the same to the victim as well as striking out the original record about the initial entry bring heavy burden on the respondents for proper explanation. So this is the statement made in paragraph 6 of this affidavit, raising doubt against the state of action. They said that oxygen facility was not given, ambulance facility was not given, rather it was the patient was taken to Silchar Medical Hospital in a police vehicle. And the reason has been stated by this doctor in his evidence that the oxygen was not available and there was no time to wait to call for an ambulance having oxygen facility. So this is the explanation given by him. So the doubt raised in the paragraph 6, this is not correct in my respectful submission. Then Lordship may kindly take up the relevant portion of the report. I'll not read the entire. Kindly come to 121, page 121. Para 11. In the inquiry, the witnesses who seem to be material are examined. The deceased Azizur Rahman was brought to the Kalayan police post in the night of 6/7/2012 as his son was not found in the house. Kalayan petrol post GD entry number so-and-so reflects that IPS officer so-and-so deputy SP headquarters had left the post for apprehending the accused in connection with Katigora PS case number 279 of 2012. The deceased Azizur Rahman was not brought to the Kalayan petrol post as an accused, but he was brought to the post so that he can bring his son to the post. The arresting authority police has not followed the provisions of section 50 and 50A of the CRPC while bringing the deceased to the post. Badrul Islam Borbuya, who accompanied the team to the house of the deceased Azizur, said that IPS officer informed deceased that he was also identified in the video recording of the incident on 4/7/2012. The IO of Katigora PS case number 291 of 2012 had said that till 12/11/2012, there is no evidence that deceased was identified in any video recordings. The witness Motiur Rahman Mayur, he is the main witness, stated before inquiry that he witnessed the torture on Azizur in the post and informed the family members of the deceased, on which date he informed the family members of the deceased is not clear. The deceased was brought dead to Silchar Medical College Hospital. The examination of the dead body was done within 24 hours of death. The witnesses who claimed to notice the torture of the deceased has not named the promoters. During the inquiry, this is important. During the inquiry, the doctor who conducted the postmortem of the deceased narrated in detail the way of examination is done. On the question whether there is any chance of getting fracture on neck bones if X-ray is done after postmortem examination, he said that the chances is very negligible and almost nil. The statement was given by the doctor before receiving the report of forensic examination of viscera. After receiving the FSL report of viscera, Dr. P.S. Sharma, head of Department Cardiology, Silchar Medical College Hospital, was examined as an expert. He said that cholesterol and atherosclerosis develop from late childhood and adulthood which hampers blood flow in the coronary artery. It may remain asymptomatic. Sudden spasm or deposition of blood clots cause arrest of blood supply to the heart, which is called acute coronary insufficiency. When there is acute coronary insufficiency, the heart may stop functioning suddenly and that may cause arrest of blood supply to the brain. So the death, as per the forensic report, the death, the reason for death is syncope. It is stoppage of blood flow to the brain. That may happen for many reasons. The reason which in the additional affidavit now they are trying to suggest is the physical assault given to the person deceased at the police station. But the medical report, medical evidence which are available here, it suggests that there is no such, it doesn't suggest that injury, infliction of injury on the deceased. And finally, the para 16 of the report, regarding the cause of death of the deceased, the same is not due to any injury on the person of the deceased. So after the inquiry 176, the CRPC inquiry, the report says that this is not because of any injury on the person. Ultimately, he died of syncope because the stoppage of flu. So this report, they are relying only referring to the witness of Mohibul at one point of time, which is in my respectful submission, is an afterthought. And in fact the report suggests if we take the entire report, the report says the evidence of the doctor, the postmortem report, the other materials for the opinion of the expert, it doesn't suggest that there is any injury on the body of the deceased. So the additional affidavit which is filed, the case projected in the additional affidavit is not correct. Now, the one vital aspect of this case is Lordship kindly consider that already now whatever report is there, whatever evidence is there, and investigations have been done, and it is pending for the trial. So at this stage, with this material, when these materials are available there, and they have a remedy, in the competent court is looking after the matter. So further inquiry by an agency is not called for. And in fact, if Lordship doesn't, if Lordship, this honorable court refuses to direct any inquiry, it is not a case that the everything will end here, because the case is pending there, trial is going on. If the evidence has, if they can admit the evidence, they can prove, in fact, there is something, law will take its own course. At this stage, therefore, my respectful submission is the prayer made in the writ petition for an inquiry, further inquiry is not called for, because only on the basis of the evidence, the circumstances narrated in the which are available before your Lordship, it suggests that Mohibul's statement, which he has given after around 20 days, is an afterthought only. Because as per him, as per his version, if it is assumable, as per his version, he informed what has happened, he informed to the family in the morning. In the evening, the FIR has been filed. And there is no reason for a person that he has seen that someone has inflicted physical torture, and he has not informed that to the family members. Had there been something, because that is the vital thing. That is the first information, that is the first important information that will come first. Therefore, but in the affidavit we have filed three affidavits, on record, we have taken three affidavits. The affidavit filed by the respondent number 1, that lordship will find at page number 8, page 81, page 81. Here it is the 154 to 1. We have said, the affidavit of respondent number 1, here we have said, because the paragraph F, small f, page 84, we have said, that during investigation, the investigation officer, amongst other, examined Dr. Suman Bhomik and recorded his statement under section 161 of CRPC. In his statement, Dr. Bhomik stated that on 7/7/2012 at about 1:50 a.m., Azizur Rahman was brought to Kalain FRU in serious condition. His blood pressure and pulse were low. He examined Azizur Rahman and gave an injection. Name he has referred in his evidence. Suddenly he got heart attack, hence referred to Silchar Medical College and Hospital. He did not find any torture mark in Azizur Rahman's body. Dr. Bhomik clearly mentioned that due to sudden heart failure, his health condition deteriorated. So this is not a case of death because of custodial torture. Documents we have annexed, and the final report we have annexed in this affidavit. The final report says, if lordship kindly comes to annexure D, page 96. In page 96, annexure D, this is dated 12/12/2012. This is the final opinion. In reference to the above noted case, on the basis of postmortem examination findings and after receipt of chemical examination report, no poison was found in the exhibit number so and so, while report number so and so dated 12/9/2012. I'd like to inform you that, in my opinion, the case of death of Azizur Rahman was syncope following acute chronic coronary insufficiency. In fact, the postmortem report and other reports, other materials available before your lordship, no injury is there, no injury mark is there. Well, my respectful submission therefore is there is no custodial torture on the person, and then this cannot be treated as custodial death. Lordship's order, one order is relevant, but I'll just pointing out. They ordered it at 28/6. Well, the death is because of the reasons, the medical reasons. So the Lordships ordered it at 28/6/2023 in the record which is available. Ultimately, Lordship has said that on the issue. (28/6/2023). No? Finally, in this order, respondent number 17 and 18, they were the doctors. Lordship has deleted their name from this. And in the last paragraph, I'm just referring that on the issue raised in this writ petition as regards custodial death of the father, Mr. So-and-so, counsel for the petitioner seeks an adjournment for further examination of the matter. So we are on this point. I'm just referring to that because other prayers have already been 28/6/23. Yes, they were struck off last para. Last para. Last. So thereafter, the additional affidavit 75, additional affidavit has been filed on 4/6/29/5/25 and 4/6/2025. One additional affidavit, the affidavit which I have read, it was filed on in the month of May 23. After that, two additional affidavits were filed in the similar time. আপনার এডিশনাল রেভিনিউ অন দিয়ক না পেজ 161 আর 171 পেজ 161 and পেজ 171 please 161 the last one yes it will go with cover up. Yes, one is 29/5/25 and other is 4/6/2025. Paragraph 3 of that affidavit, madam. There are 3 of the affidavit. This is already stated in the affidavit which I have already placed, madam. Para 3 of this affidavit, the affidavit at page 161, it starts at 161. The relevant is 162, page 162, para 3.
Yes.
There,
We did not follow a link. You're trying to say that after that order, these 2 affidavits were filed.
yes,
And in these 2 affidavits, the storyline has digressed.
same, similar, already
Similar. Okay.
it is similar. They said that he was brought there to the police station, to the hospital, and due to pressure from higher police personnel, he had strike out the original entry in the register and then referred the patient to the Silchar Medical Hospital. This is already stated in the earlier affidavit. Earlier affidavit, para 5. In this affidavit, the petitioner has also stated about the investigation and the non-acceptance of the FR. Then again, direction of reinvestigation and all other things they have stated. And ultimately, they said that this is a custodial debt. But the reason being that the main contention remains in para 3. To award compensation for a for a death in because of custodial torture, Lordship will see the materials available on record, the postmortem report and the evidence of the doctor, the report of inquiry under 176, until and unless it is established that because of torture of the person and because of torture and excessive when the police officers or the custodians exceeds their jurisdiction while discharging their duties, in that case, Lordship will direct compensation, otherwise not. This is not a case where while discharging the duty, the police has exceeded their power and because of torture, he died. One decision, my lord, I will place, and then I have, in another matter, I have placed it before lordship earlier. That is Subhay Singh's case, my lord, 2006, 3 SSC 178.
Please keep that citation again.
Lordship, 2006, 3 SSC 178.
178.
8. Yes, my lord.
Name of the party?
Subhay Singh versus State of Haryana. Because compensation, when lordship is directing payment of compensation, the compensation lordship will direct as a public law remedy, my lord. So para 31 discusses all the cases, my lord, right from Nilabati Behra and all the cases have discussed. I'll take your lordship to, relevant is 31, I'll take your lordship to para 40, my lord.
Please give us the citation.
Yes, my lord. 2006, 3 SSC 178.
No, you have given a printout now.
I have not given print out. If I'll fund it.
It's okay.
I'll fund it. Has lordship got on?
That's the motion.
Lordship.
Paragraph numbers.
Para मतलब the 31, 38, 45, 46, 48, 7 and 48.
45.
46, 47, 48. Para 31 to 39, मतलब the compensation under public law remedy, all the case laws have been discussed. Para 40, मतलब also kindly note para 40.
Paragraph 40. MC Mehta.
Lordship, it is under the heading whether compensation should be awarded for every violation of Article 21.
Yes.
Lordship, before that, kindly just para 38 for a moment, no? 38. It is all the cases have been discussed. Then court has said that it is thus now well settled that the award of compensation against the state is an appropriate and effective remedy for redress of an established infringement of a fundamental right under Article 21 by a public servant. The quantum of compensation will, however, depend upon facts and circumstances of each case. Award of such compensation by way of public law remedy will not come in the way of the aggrieved person claiming additional compensation in a civil court, in the enforcement of private law remedy in tort, nor come in the way of criminal court ordering compensation under section 357 of the Code of CRPC. Then the discussion is whether compensation should be awarded for every violation of Article 21. Then MC Mehta, DK Basu, Shakil in subsequent paragraphs have been discussed. Kindly come to para 45. Para 45, may I read? Cases where violation of Article 21 involving custodial death or torture is established or is incontrovertible stand on a different footing when compared to cases where such violation is doubtful or not established, where there is no independent evidence of custodial torture and where there is neither medical evidence about any injury or disability resulting from custodial torture nor any mark scar, it may not be prudent to accept claims of human rights violation by person having criminal records in a routine manner for awarding compensation. That may open the floodgates for false claims either to mark money from the state or as to prevent the thought further investigation. The court should therefore, while jealously protecting the fundamental rights of those who are illegally detained or subjected to custodial violence, should also stand guard against false, motivated, and frivolous claims in the interest of society and to enable the police to discharge their duties fearlessly and effectively. While custodial torture is not frequent, it should be borne in mind that every arrest and detention does not lead to custodial torture. So ultimately, paragraph 46, 47, and the 48, Lordship, referring to this case, my submission is that for custodial violation, in fact, it is alleged in this case is that the custodial violence has to be established. Therefore, in my humble submission, since the torture injury mark is not there, torture mark is not there, the documents available is not, doesn't suggest. Therefore, the investigation and the compensation as read in the writ petition may not be considered at this stage, and vis-a-vis at the same time, Lordship will also consider if the case is going on. Complaint case is registered, it is going on, and if at the conclusion of the trial, if somebody is found guilty, definitely they will be punished.
With the permission, my lord, I have to make some assumptions, my lord. First of all, my learned friend has raised me regarding delay in filing the affair. The incident occurred on 7/7/12 and we browsed the affair on 8/7/12. That is. But second thing, that while reading my learned friend, the witnesses about the inquiry report, my lord, most vital witness, the constable accompanied with the accused, present respondent number 6, that part not read by my learned friend, my lord. And 3 eyewitnesses, my lord, my learned friend only harping on the Mohibur, my lord, whereas the rest 2 others evidence also, my lord, corroborated, my lord, and their corroboration, my lord, inside the custodial, my lord, on which the color of the chair, in fact, the constable also said that the red chair, my lord. That witnesses also said that while allowed to see the Azizur Rahman, that the red chair, that even constable said that the red chair, my lord. My learned friend skipped that part. My lord. Most important question is, my lord. Recently, my lord, respondent 6 has filed 1 affidavit in this matter, in paragraph 5 specifically, my lord, and termed my deceased father as an accused, my lord. Termed that the police team found accused Azizur Rahman, my father's, given a term as accused, and another time used, my lord, that accused person was shifted to come. In all the sentences, my lord, my father, deceased father's term is accused, but whereas Witness number 10, he's the constable who accompanied with the dam. He was said that he was not arrested for interrogation. He was brought to the police outpost. How the respondent number 6 give terms to the accused? My father was not an accused, my lord. No affair against my father, my lord. Admittedly, witness number 5 is the constable that is Muhammad Safiul Hussain, my lord. Only relevant person I will read, my lord. So he also named the regarding 3 witnesses name, but relevant person said the Azizur Rahman was brought to Kalan PP for interrogation and he was not brought on arrest. My lord, page 40, 113 of the inquiry report, my lord. My lord, witness number 5 and witness number 10, your lordship give permission, I will read it. Witness number 5. Investigating officer, Muhammad Safiul, the investigating officer, my lord. On 10/2012, DIG SR has entrusted him with the investigation of the case. On so he deputed a constable to collect the Vesira report from the FSL Kahilipara. The constable informed that when 7 days of the report will be furnished. On so Sajal Paul visited the place of occurrence, examined the complainant, Saleha Begum, my mother, my lord, Razia Begum, Salim Ali, Meherban, mainly important, Tasuddin, Rafiquddin, Mohibur Rahman, and Sahiduddin. He named the 3 witnesses and Abdul Haq, Anwar Hussain. The constable, Laliti Singh and Badrul Islam Gorbhia, the Kalayan Hospital GD entry, on 27/9 and GD entry number 1587712, time at 1:45. My lord, time is very important here, my lord. In this affidavit and this is time is 1:40 AM, reflect that YT Getso, ITS, with his staff, has returned to the post with the suspect Azizur Rahman. That means at 1:45 AM, my lord, my father was brought to the outpost and 1:45 reflect that Azizur Rahman was sick before interrogation and hence he was sent to the Kalan Gov Hospital accompanied YT Getso along with his staff number J.S. Bhomik was the doctor of the Kalan Hospital who examined the Azizur Rahman. On 7/7/12 at 1:50 AM, doctor referred Azizur Rahman to Casualty Department SMCS. The certified copy of the refer register showing the relevant entry at is in the case diary. Now, my lord, the Azizur Rahman was brought to Kalan PP for interrogation and he was not brought on arrest. No family members, relatives, or friends accompanied Azizur while brought to the post. As per the statement recorded by the IO Lake Soikia, Badrul Islam Kalan Syamal Chakraborty, there are the persons who accompanied the team to apprehend the Azizur Rahman. And so Lali Singh was the sentry duty and the LC duty. As per the Gungur OPGD entry number dated 5 AM mentioned the Azizur Rahman dead and preparation is being made for the inquest and postmortem examination. Dr. Gunojit Das has conducted the postmortem on the dead body and this is Azizur Rahman My lord, admittedly, my lord, this investigating officer has named those 3 eyewitnesses' names, Tasuddin, Mohiburuddin, Sahiduddin, their statement he is taken, and also stated that my father was not brought as an accused, for interrogation only. He was not brought in arrest. But whereas in the affidavit filed by respondent number 6, is the term used by them, my father is an accused, my lord. Now, my lord, most important witness is, my lord, witness number 10. This is Shyamal Chakraborty. He is the constable, my lord. At page 118.
Look, can I just finish? Just come.
Page 18, 118, my lord, 180. Witness number 10, my lord. on 1910-12, Sri Shyamal Chakraborty, Ajizur Rahman Constable examined. His statement is so-and-so. On so-and-so 6/7/12 at 9:30 p.m., he proceeded from Silchar with IPS officer YC Getstro as a so-and-so. On 10:30 to 10:45 p.m., they reached the Kalan police outpost. The officer went inside the office. They remained in the front side in the third room. Suddenly, the officer directed them to proceed. They boarded the vehicle and went towards Borital, being guided by the constable Kalan petrol post. The officer Badrul Islam and Omen constable went to the resident. Other remained outside, cordoning to the house. Some ladies and one old man came out. The old was directed to bring his son to the police post in the next morning at a.m. by the officer. The old man expressed that if his son is not found, he will not be able to bring. The old man then expressed that he be taken to the police post. Then the IPS officer slightly pushed the man and directed to accompany the party. The IPS officer directed him to inform the ladies that no harm will be done to the old man. Accordingly, he informed one of the girls who followed them with a torch and asked her to go back. The old man walked to the vehicle, which was parked about 170 yards from the resident. The old man, after landing from the vehicle, went to the post and wanted to sit on a bench on the second row of the IPS officer. Directed them to bring a chair for the old man. They brought a plastic chair for the old man for sitting. The chair was the color of red. My face, my lord, only that part only. That all the witnesses, Mohibur and the rest two other witnesses, they have seen that the specific what they have said, I have to read that part only, my lord. This constable also said that the color of the chair, in fact, my lord. Yes, they saw that Mohibur Rahman said that, my lord, they saw that the police set Ajizur on a red plastic chair and arguing with him. And suddenly two police held the leg of the Ajizur and one tribal police officer held that head and face of the Ajizur and gave a jerk, my lord. This evidence, my lord, Mohibur, Tajuddin, as a Sahiduddin categorically stated this, the color of the chair, the inside, that means these witnesses have seen what happened inside that custody, my lord. Now, my lord, and paragraph 11 of the inquiry report also admitted that all the incident, my lord, whatever the respondent has done, my lord, is a violation of the section 50 and 50A of the CRPC, admittedly, my lord. Now, my learned friend, my lord, argued, my lord, but the most vital point, my lord, yes, yes, my lord. Though Dr. Gunajit, my lord, sorry, my lord. Yes, Dr. Gunajit does the witness number 7, my lord. In this report, in the respondent one has enclosed his final report that it is the death of a syncope, my lord, the death of a syncope. Whereas respondent number 1 in his affidavit said on what basis, from where he got this evidence that he's a so higher officer, my lord. Respondent number 1, he's the joint secretary. How he can say the heart attack? He died on heart attack, my lord. On which document was available that my father was died on heart attack, my lord? The heart statement given from where, my lord? Most casual manner, the statement made before the honorable court, my lord. And my learned friend is my lord. My lord, syncope term it is given with something internal, something force that pressure, my lord, anything might happen, my lord. That therefore they, yeah, my lord, and didn't admittedly, my lord, my father was a, my lord. A sudden shock, my lord, shock and sudden shock, heart failure, yes. My lord. My lord, I respectfully submit in this matter, my lord. While my father was brought to the outpost, my lord, he was an absolute natural person, no disease was there, my lord. And my lord, within short period, my lord, within that short period, that incident occurred, my lord. And the point number 6, my lord, file affidavit, my lord, in paragraph 5, only specific paragraph 5, I like to read, my lord. At page 182, paragraph 5. Kita cancel it. We put topical 150 and what? Oh, that market. Oh, sorry. Oh. Yeah. Logical report. Maybe inquiry report. Oh. 12. Inquiry report. Oh, yes, right. My lord. Yes, my lord. Best 182 paragraph 5. That with regard to the statement made in paragraph 4 of the writ petition, the deponent denies the correctness of the said and further begs to state that the police took lawful steps to apprehend the alleged involved accused persons of the aforementioned case in the interest of the investigation. As per the instruction of the Superintendent of Police, Kasar, a police team, including women police personnel, was formed under the leadership of the deponent for aforesaid purpose. On Swench intervening night on 6 and 7 July 2012, police team raided the house of Muhammad Azizur Rahman at Choenso under Kalan Police Patrol. The police team found the accused Muhammad Azizur Rahman available in the house. However, Muhammad Najimuddin, accused person of the Katigora PSS, was not found available. A little after 1 a.m., the deponent, along with the staff, brought Muhammad Azizur Rahman to Kalan Post, which was situated at a distance of 500 meters from his house, for examining him to connection with the aforementioned case. On reaching Kalan withdrawal post, he was made to sit on a chair. Thereafter, deponent went out for the patrol post for further patrolling. So here, my submission is, my father was brought to the outpost, he was allowed to sit, then he left went for some other patrol post for further patrol. That means the statement it is given it, that means the respondent number 6 was not available there, After leaving my father there, he was allowed to sit inside the outpost in the chair. Thereafter, deponent went out from the patrol post for further patrolling. After a while, when he came back to the patrol post, he found Muhammad Azizur Rahman in an unconscious state. As such, matter was immediately brought to the notice of the then Deputy SP, Silchar, who was in an adjoining room following his duty shift, and the accused persons was shifted to Kalan FIR immediately. I can use the word terms of accused. It was learned in the meanwhile that while sitting on the chair, the accused persons mentioned uneasiness and then dropped down and become unconscious. At the Kalan FRU, the medical officer on duty, after examining the patient, referred him to Silchar Medical Hospital, and accordingly, the accused person was shifted to SMCS Silchar. Subsequently, deponent learned that attending doctor Silchar, after examining the accused person, had declared him brought death. Also, that in this regard, the case was registered category Silchar. My specific argument in the specific paragraph 5, my lord.
Then the answer is very simple. We give you liberty to file a defamation case if he is termed as an accused as a wrongly.
No, no, no,
In this,
no, no, my
in
lord.
this
Term
repetition,
using,
what when convert can you do?
term using accused is not by submission, my lord. Term using not accused. This just used that word. You know, as it meant, my father was accused
You see,
for the reason he
we
was
talked
arrested.
about it. In this, till now, in this argument you have been making for last 2 days, we have not even come across the original FIR in 288. The FIR lodged in 288 is not available before us. At least nobody, neither you nor Mr. Nath has pointed out. So we don't know the contents of the FIR of 288. So who is the accused person? We don't know. Therefore, we can't
That
say.
affair,
At best, if you are aggrieved by this, you may find that information soon.
that affair is not available with us.
So whether he's an accused or not,
It's
we
a-
don't know.
it's a-
We can't make an inquiry.
It's a police authority, my lord, that affair, my
We
lord.
understand, but
That affair is, it is not possible to brought on record, my lord. And while lodging this affair, my lord, at page 14, my lord, in the writ petition, my lord, much is a good question. When a doctor asks, is the chance to getting fracture at neck if X-ray is done after postmortem? The doctor said the chance of getting fracture is very negligible. And if you can negligible, that is negligible. Fracture is negligible. Fracture negligible. Fracture don't have chance to open body. Swelling আছে, swelling to আমি দেখিছো, রিপোর্টত নাই না। গলা ফুলা কিবা ফুলা, গাৰ পকা। When a doctor asks if any chance to getting fracture at neck bone if the X-ray is done after postmortem, the doctor said that chance of getting fracture is very negligible. Almost in the doctor said still photography was also taken. If আমি photo evidence কোৱা নাই যে swelling throat, my lord, in the affair, my lord, we have said that when our father was handed over to us, my lord, and we all my family members and we have noticed that there is swelling in the throat, my lord. It is clear, my lord. But in the evidence of the doctor, my lord, Gunojit Das specifically said that when a doctor asks, is there any chance of getting fracture of neck bones if X-ray is done after postmortem? Doctor said that the chance of getting fracture is very negligible, almost nil. That means, my lord, that part has been, we have noticed that there is swelling on the neck part, my lord, but this is negligible, not possible. That is also, my lord, some. My lord. It is absolutely very. Actually, Dark, yes. Yes, my lord. Yes. Now, the question, the main question is, my lord, the date of my father is a natural. Yes, my lord. Yes, proceed. Only the specialist, the medical practitioner might, my lord, might. But only on the assumption, matlab, we are just assuming, my lord, this thing happened. But we want the perfect exact. The question is, my lord, but main come, my lord, my father's death is a natural or unnatural death, my lord. This is the main issue, my lord. And since natural death, my lord, it's my father, he was sleeping at my home, my lord, but this incident occurred when my father was at the outpost, police outpost, my lord. And also, my lord, in the medical report also said that BP not recordable, death condition faced my father, my lord, and all these things, my lord. Something that respondent number 6 brought my father to that. hospital, my lord, and some deletion is there also. No one is ever about this. Then my father referred to that Silchar Medical College. All these things, my lord. Done by the church. It was the very likely regulation professional. Visualization. Visualization involve twisting can cause deep issue into the in the day of due to neck twisting, resulting injuries can sometimes be mistaken for strangulation or parental situation. That's not the charge will be where I come mark for this ये कुछ प्रदर्शन तो मारा मारा हो मैं आपको कहिए तो जब भी मारता हूँ इस क्रॉस तो रोशनी का प्रश्न जाती deeply regulate interacting the fat space with it involve twisting. It can fingernail separation. Push. Yes, not. But starting with a course, but fingers will be the possible. It's the time. Finger punch courses. Thank you. That is something so. That's only this is the thing. This is it was paragraph 11, 12. Okay. And my lord, in this regards, my lord, with written argument with some citations, my lord, I have enclosed and for lordship note, can my lord. Written argument with citations, I'm relying, my lord. In details, I have facts from the narrated, especially paragraph 11, 12, my lord. Finally. And why we have requested paid for investigating for in independent inquiry, because my lord, twice my lord final report placed resented my lord, so we lost our confidence on them. Therefore, we are praying for any investigating authority to investigate the matter, my lord. Oblige, my lord.
And if the enough, then it can you come with the new it's part of numbers. They come with no understand any kind of because of me. Corresponding to 1 to 5. 6 is not appear there.
Do not go 6.
6 in case the council. No, he is not for 6.
No, they are not representing 6. Six.
But represent for 6 also. Yes, sir. Okay, then 1 to 6. The sufficient in reply by the Lorette Senior Government Advocate and counter reply by the Lorette Counsel for the petitioner is concluded. This on transfer for verification if any. We did after 2 weeks. You were hearing this. 14.
My lord.
Go through it in the meantime.
My lord. Much obliged.
Verifications required will take.
Much obliged.
For that mistake. We get the contract. We submit a written argument on behalf of the petitioner along with case side. It's
Obliged.
as a part of it.
Item 12 for hearing. Item 13.
Please tell me more.
Item 14. Item 14. Item 15.
Yes.
My lord, of the order, my lord, page 14. By this, mandatory burden of proof that she is an Indian citizen and the side of the section. I was not able to discharge my burden at section 9, my lord. As many as far as this order goes, my lord, as many as 6 documents that I have exhibited, my lord, to establish the link with my father, my lord. As far as this order goes, my lord, I'm on record that really the document that I have exhibited, my lord, page 16 and 17.
But I'm very sorry to say, I was waiting in the corridor, my lord. My item was 12, my lord. At least, my lord, I will be praying for some time, my lord. They're producing some, my lord, judgment, my lord, in my favor, my lord. The proceeding is a, my lord, female, my lord. And the only linkage with her father is the, my lord, deposition of her father. Today, I have not come with the, my lord, citations with the, my lord, different high courts as well as the Supreme Court, my lord. In the next week, my lord, any date, Lord, will kindly fix, but come with the, my lord, citations. Item 12. It goes after 2 weeks. My lord. Item 12. Item number 12. Item 26, let's say the representative of the fair made by unconscious petition, attachment list on 19. Right. 13 also same thing, but we were 13. 13, I mean 13. 13 also same thing. Obliged action.
I these 2 documents, my lord, can I see the answer?
Yes, please continue.
My lord, these are the documents, my lord. Exhibit 4 and 5, my lord. These are the only 2 documents to establish my link in the father. Unfortunately, by these 2 documents, my lord, that was not proved, my lord. Even though exhibited, not proved, my lord. Other than these 2 documents, my lord, I have nothing on record to establish my link with my father, my lord. I do not want to waste the judicial time of this court, my lord. These 2 documents that we have relied on, my lord, was not, even though exhibited, but not proved, my lord. Other than these 2 documents, my father document is there till 1970, but after that, my lord, even my voter list, even though it's exhibited, my lord, my father name was not rightly mentioned in this.
And the panchayat secretary, the panchayat, and that
Yes, please.
village government
Page
counter certificate.
counter certificate, my lord. But it was not proved, my lord. Other than these 2, page 16 and 17, my lord, Sarkari Gauhati and then GP secretary, countersigned by the block development officer, my lord. Even I have been trying to reach out to the client, my lord, for last couple of months, my lord. Even written a letter that in the month of January, I came to know she is not feeling well. And thereafter, I have, because it has come through some of my engaged advocates, my lord.
Okay, Peter, John, take it back.
I'm deeply obliged, my lord. I'm deeply obliged.
That's the of the fair made by unconscious. Attachment list on.
I'm deeply obliged.
Item 16 for hearing.
This matter, I am challenging the action taken by the respondent bank against the flat of the petitioner. The bank is the UCO bank. Nobody is there on the respondent side logs. My ground is that bank has no jurisdiction to
We
initiate.
have been having a bad reputation.
That's it.
We are perhaps having a bad reputation that the hearing will not reach.
No, lordship.
Oh, yes, come. Oh, no.
My case was that neither I am a borrower nor the guarantor. Despite that, bank authority has initiated surface action against the claim of the petitioner. I have purchased the flat by way of registered sale deed way back in the year 2000.
Remember it, that flat number 402 or 403A, 103A or 2.
No, lordship, that is not the case. I have purchased.
The flat was renumbered.
No, no, no. No. My sale deed is at page 19. Page number 19 is the registered sale deed executed on 20 April 2007. Page 36. Yes, Your Lordship. This is the notice issued by the bank authority. Yes. Pranjal Moran. He is a builder. Gargi Associates, Upasana Builders, all are his companies. He expired already. Yes. Obliged. Not. There's several litigations at his lifetime. Myself. Yes, yes. There are several litigations. No, he himself purchased it, the builder. The company executed the sale deed in favor of the, not a sale deed, agreement for sale. And thereafter, the managing director of the company itself obtained the loan.
Item 17.
Usually they can go on any other way. Any other way motor can be on the frontal part has to be.
My lord,
Yeah, my lord, but after. Combo.
no, my lord, in this case, the lordship wanted us to file some bullet points on the last page. That's right, my lord, that's right. But we'll file that that point for lordship's order for them. We'll file it now on the next. Any day, we might. Sí, vale. Ah, ¿cómo? ¿Tú lo muestras? Sí. October, yes, yes. Yes. Lordship, far the better, I am told. Obliged, Lordship.
Time being item 8 for hearing.
21st thing.
Timing item 9 for hearing. Timing item 5 for admission.
In this matter also, Mr. D. Nath is appearing, Your Lordship.
Dina can appear also. So that's this matter and activity.
May 23rd of May.
Deeply obliged, Your Lordship.